My name is Jack Dwyer, and I'm the Executive Secretary of the Water Resource District Association. And thank you for all joining us. So today I want to thank, for those of us that weren't here with us for any of our previous presentations. We are putting these presentations together or on virtually on behalf of the Water Resource District Association and the Water Education Foundation in partnership with the State Water Commission. This is in replacement of our summer convention, and also it's in replacement of the in-person trainings that we planned on doing in 2020, which in 2018 we did around the state of North Dakota. So anyways, I want to thank Sean Fredricks, who's here today. Sean Fredricks, as you know, is a household name in the water community and has a solid reputation for providing legal services to water resource districts and water supply projects, primarily on the eastern side of North Dakota. Sean is a shareholder at Onstead Twitchell Law Firm in West Fargo, and he is one of our only, if not the only, lawyer in North Dakota to practice water law exclusively. And he represents, he's got nearly 20 years of experience, and he is a leader in water in the state, and he appreciates his relationships with other water leaders and boards throughout North Dakota. So Sean, I guess at this time I'll turn it over to you.
Hey, thanks, Jack. I'm gonna share my screen here. Let's see if it works. One thing I've noticed just while Jack was talking through that was that my face looks a lot older. I don't like to look at it, so I don't want anybody else to have to do that either. As you can see, I'm got a big TV behind me. I'm in what was once my wife's workout room and has now become my home office. So weird times for all of us, and it is what it is. So everybody's making do. You know, it's particularly difficult for water entities because we rely on meetings. And, you know, I think a lot of the boards I work for, we've been doing almost all of our meetings virtually, and I think we're getting along just fine. You know, a lot of times you miss that personal contact, and sometimes you think you're not going to grasp a situation if you can't get a sense for what's happening in the room, and there is some of that loss, but I like to think we're all doing pretty well here with the situation we have. So anyway, I'm going to work through a couple issues. The first piece is going to be right of way, and I'm not going to do an extensive, exhaustive discussion of how you do right of way. I just wanted to touch on a couple of issues. Number one is it's legal drain related. So for some of you water managers who don't construct legal assessment drains, it may not be terribly crucial for you, but still might be interesting in terms of some of the projects you're working on anyway. And then the other issue, and that's going to be related to berm easements. The other issue for right of way will just be quick take, some discussion of water resource district quick take. I think we've been living with the new bill, the new quick take statute for a few years now, and just wanted to talk through it a little bit. Then I'm going to talk about legal drain crossings, culverts, bridges. Those are probably the most frequent questions that I receive. Who's responsible for this culvert? Who's responsible for this crossing? Who has to pay for this, etc. So, and I do this one every few years, and I think the last time I did it was in 2016, I want to say, at the winter convention. And so I figured it was a good time to pull that one out. Sometimes I offer that one at township association meetings, and I think it'd probably be helpful to do that again. But we do get a lot of disputes between, I shouldn't say disputes, but a lot of competing questions from townships and water resource districts. So I think we need to do a better job probably educating some of these road authorities as well. So anyway, that's just a little overview of what I'm gonna go through here. Let's see if I can get this thing. There we go. Of course, we gotta start with that. I think we're gonna have an interesting football season if we have one, right? Some of you are probably UND fans and are cursing me right now, and I appreciate all of that. I should say, before I move on, one of my good friends, Kevin Feeney, played quarterback when I played. Some of you may know that name. His son recently committed to play quarterback at UND. So interesting how those paths are divergent here. UND's doing a nice job. I think Bubba Schweiger is an old family friend of mine, so I like to give him a hard time. But anyway, it's gonna be interesting to see what happens with football and with everything else in the world, right? All right, let's get down to it. So we're talking about legal assessment drain berm easements and then quick take eminent domain. And the berm easement piece, again, that's specific to legal assessment drains, but some of you who maybe don't construct legal drains, you may have other types of water projects where you need buffer zones, and this may relate in some way to that. So it may be somewhat relevant. Hopefully you get something out of it. So let's get right to it. We'll talk about right-of-way acquisition for legal assessment drains and the types of right-of-way that you need for each drain. So for many years, at our firm anyway, and Dick Twitchell, a lot of you remember that name. Dick was synonymous with water in North Dakota for probably 50 years, and he worked closely with Mike Dwyer and Dave Spencenatic and a lot of the people who are sort of the giants in water, and I learned from Dick. And so one thing that we did for legal assessment drains that Dick had been doing for many years, back before water resource districts were created, which I think was in 81. It was in 81. Before that, there were water conservation districts, things like that. A lot of precursors to water resource districts, drain boards, things like that. But Dick, for his right-of-way, he would acquire, on behalf of the water resource district, he would acquire right-of-way for the channel, usually in fee simple. And, well, I did note that you could also do it in permanent easement. From Dick's perspective, if a landowner was pretty adamant that, hey, look, this property's been in my family for generations, I'm not giving it up. Okay, well, just give us an easement. That's your prerogative. Of course, the landowner then still has to pay taxes on it, and they can't use the property. But anyway, so at any rate, for the channel and the berm, what we used to do is just get fee simple and permanent easement, and then for the back slope, and I'll have a diagram that I'll show you here shortly. For the back slope and the construction area, temporary construction easement area, and some of those overlap, we would just get a temporary easement. And what happened was, well, let me run through what we do now, and then I'll get to the diagram, and it'll explain a little bit more here. But now, based on some disputes we had with landowners over that back slope, we acquire 3 different types of property interests for a legal assessment drain. Your channel acres and your berm, I still offer and suggest that water boards offer the opportunity for landowners to convey in fee simple or permanent easement, either one. Again, same issue. If a landowner really doesn't want to part with their property, they still want to own it, still in their family, has been for generations, okay, give us a permanent easement. They won't be able to farm it, they won't be able to use it, and they'll still have to pay taxes on it. But that's important to some people, and that's okay. I think you gotta work with your with your landowners, right? The back slope is where we have a change. Probably in the last, I don't know, 12, 13, 14 years, we started moving towards these permanent, what we call berm easements. And again, when I show you the diagram, that'll make a little more sense. And then, of course, you still have your temporary construction easement area. So here's the promised diagram. So Maple River Water Resource District is constructing a project right now, and Kurt Lisney and Brady Woodard at Moore Engineering were friendly enough to provide their old buddy, number 46 here, aerial photo. And this is just a good example of what we're looking at for a legal assessment drain. So the interior lines, of course, that's our channel. Those are our channel acres. And then there's the double lines on either side where you're talking about your berm, right? And so what we want to do there is we want to get, as they noted in the diagram, fee title, or again, permanent easement. And again, obviously landowners cannot farm this. One of the things is, I should note, if you do get well, even if you get it in fee title, but especially if you just get an easement, landowners are often inclined to attempt to farm portions of the berm. And, you know, we get that every year. We get people farming too close to the side slopes. They're getting on the berm and maybe causing erosion. So that's one of the reasons boards like to get fee title as opposed to easements. But in my view, if somebody's going to farm that berm, they're going to do it no matter what. And so you're going to have to figure out a way to sort of police that. So that's just a quick side note, but don't let people farm your berm, and I'm sure you all know that. So the permanent spoil easement, farmable back slope over to the left, that's really what I wanted to talk about. And so you have your channel, you have your berm, and then you have a back slope. And so what we used to do is we would include those acres in the temporary construction easement acres. And it was all just grouped into one. We just have one temporary easement, usually for about 3 years. And the idea was we needed access, obviously, for construction. They weren't going to be able to farm. We'd pay them what we were going to pay them for temporary easement values. And then at the end of the 3 years, the easement expired, but then they still have a back slope there, right? And Dick Twitchell, working with one of the boards in Cass County, it happened to be, he went through his typical process that a lot of water boards, by the way, still do today. Typical process, acquiring fee title for the channel acres, and acquired permanent easement in that back slope area. Excuse me, temporary easement in the back slope area. Everything's moving along just fine as usual, right? And they've been doing that for 50 years. Well, one landowner, represented by an attorney here in Fargo, whose name I won't mention, but who has made a nice career out of challenging water boards and cities, realized that, listen, your temporary easement expired and you still have a back slope out there. So either we're going to rip up that back slope because we're going to use it to develop. He knew obviously that they couldn't do that. That was going to damage their drain. They needed the drain just like everybody else. But we're either going to rip that up or you're going to pay us to acquire a new easement on this back slope area. And by this time, Dick had retired. But, you know, it was typical practice. So what ended up happening is if it was going to go to court, right, then you probably have some sort of easement by adverse possession, a prescriptive easement, you know, that kind of thing. We ended up paying some dollars to this landowner ultimately, so we could acquire a permanent easement over that back slope. And ever since then, you know, that was maybe it was maybe it was closer to 20 years ago. I mean, that was very early when I started with OT. Immediately after that, I started developing a new easement for this area that we called at the time, we called it a spoil easement. You know, so we could spread spoil, etc. Landowners didn't like that phrase, and you know, that's fair. So we came up with berm easement, even though we don't have the berm built there. It's just the back slope, but that gets a little wordy. So we call it a berm easement. So the idea is, and then the temporary easement acres extend beyond that. The idea is we need some permanent access. We need permanent rights. We're making a permanent alteration of that property. And so our right-of-way should reflect that. And so we developed this berm easement, and it's permanent. And so, and just as a quick side note, you know, people always note that, hey, you can't have a permanent easement in North Dakota. It can only be 99 years. I understand all of that. One of my partners is on the title standard committee, and they just sort of, they sort of disregard that, really. So anyway, that's just a quick side note. But so we have 3 types of property interests now. We get the channel acres, either in fee or in permanent. We get our berm easement, and we get our temporary easement. And so our berm easement still gives us those access rights for construction purposes, but it also gives us the right to maintain that back slope. It gives the landowner the right to farm it. As long as they don't interfere with or damage the drain, they still have the right to farm it. And I'm going to get into values here in a second, but and then we talk about, you know, we usually negotiate with the landowner in terms of, all right, when would we start paying crop damages if we're going to? Really, you're paying a value for the easement based on an appraisal. And in fact, it's probably easier if I just get into that. So again, temporary easements, the disadvantage of trying to continue to utilize that for that back slope is it expires, right? Usually 2 or 3 years. And technically, you're not going to have any permanent rights to maintain that back slope. And so you may have what we encountered 20 years ago. And ever since we instituted this new process, we've not run into it, obviously. It makes farmers a little nervous, and I understand. They say, well, look, I'm going to be farming these acres, but yet you're going to be accessing your property. And so a lot of boards will say, at the conclusion of construction, we'll start paying you some crop damages. That's a point of negotiation. But with a temporary easement, you don't have the right to protect that back slope, and that's one of the problems. So the benefit of the permanent berm easement is you have that permanent protection. You got to pay a little more upfront usually, right? And I note here that it's going to cost more upfront, but it's more accurate in terms of your crop interruption later. And I'll have some appraisal numbers, really recent values that I'll talk about here just shortly. Well, here it is. So this, what we oftentimes will do right at the commencement of our right-of-way negotiations. Let's say you've voted in a new project, or you've approved reconstruction of a drain, or whatever you're doing for your drain project. The next phase is going to be right-of-way acquisition after you get your permits and everything like that. And so what we usually do is we'll get what we call a desktop appraisal. And that just means, look, we're not going to go in and do a whole appraisal for each individual property out along the course of a drain. That could be pretty expensive. But at the same time, these landowners are going to want, and they deserve, right? They're going to want to know what an appraisal is going to show in terms of their right-of-way values, as opposed to just the water board sitting and having coffee and deciding it's going to be X amount. And then that works in some instances, and you can save a little bit of money. These desktop appraisals are not very expensive, and they're really helpful because you can provide them to the landowners, and they can see for themselves that, hey, this isn't just a number that we pulled out of the air. This is a number that a licensed appraiser came up with. And so the desktop appraisal just tells you, look, for most of the properties along here, here's the value. And this is the one I just got this week on a project we're working on. And the appraisal showed $47.50 for the channel acres. And basically the value is the same for fee or permanent easement, because again, they can't use it. And then they came up with $1,000 for those berm easement. And that's a pretty common number for this type of easement. So we see that quite often. Temporary easement, they came up with 175, and a lot of times boards will pay more than that. But you can see that it's a pretty significant disparity, right, in terms of the berm easement values and the temporary easement. And what we found over the years was a lot of landowners, when we were just paying them the temporary easement values, is they'd say, look, you're going to complete construction, and that property is not going to be the same for quite a while. And so what you're paying me a couple years worth of rent, basically, that's not sufficient, because I'm not going to get the same yield out of those acres for quite a while. And I think the enhanced value for the berm easement recognizes that. So there's a little more significant payment up front in recognition of the fact that, yeah, we're going to be disrupting those acres, and you're not going to have the same production out of those for a few years. So there's a larger investment up front, but landowners, I think, view these as fair. And the next question then is, what are you going to do about crop damages? Are you going to pay crop damages beginning the next year every time you go out there? If you have to do a little bit of maintenance, if you damage, are you going to pay crop damages? A lot of boards decide that they will, but the idea is, if you went to court on it, look, the berm easement payment up front is supposed to be compensation in full for the value of what you're obtaining from the landowner. But a lot of boards feel like it's fair that, yeah, but if we go back out there and we're letting them farm those acres, and they're granting it to us with the idea that they're going to be able to farm it. So a lot of boards will still pay some crop damages if they interfere with those acres later. Whoop. This is just some language from the appraisal that I got this week. And this is a description of the berm easement acreage. And I just wanted to show you what a licensed appraiser would say about it. As you can see, this appraiser said, look, they're still going to have full use, but there's some reduction in value, right? Because they're giving up some interest. So I just wanted everybody to be able to see what that language is right out of an appraisal. And so there's a diminished value for those acres, even though they get to farm it in perpetuity. This is language right out of our berm easement document. And I'm not going to read it all, but it just gives you a good idea of the type of rights we're acquiring over this property. So we're giving ourselves a right, basically a lot of the same language you use in a temporary easement, right? The ability to enter on the property for purposes of constructing or repairing the project, excavating, piling, storing, spoiling, spreading dirt. So that's a significant one, right? So you're talking about your back slope. So that's a significant one, and the ability to remove any obstructions and that kind of thing. But I just wanted everybody to have a chance to see what that language looks like in our berm easements. So this, these are a few pages long, but this is the real meat and potatoes of what we're doing in a berm easement. Here's your temporary easement language, and you can just see how it might differ. So this I thought would be somewhat helpful in that this is in the temporary easement document as well. This one is going to run for 3 years, but we also note, even in this one, and we used to rely on this language more heavily, but even in this one we note that over those temporary easement acres, there's a possibility that there could be some permanent alterations. So we at least want landowners to recognize that you're not going to get your property back in perfect condition immediately the moment the project is concluded. So there could be some permanent alterations if we have to remove an obstacle, etc. So now's a good time just to sit back for a second. If you have any questions, sounds like you can submit them. I don't know if Julie's fielding them, or Lance or Jack, but if you have any questions about berm easements, we've just found that going that route has a lot of landowners, a lot of farmers feel like that's a fair process, and you're giving them a larger payment up front in recognition of the diminished value of those acres, at least the diminished production value of those acres for the first few years at least, after you complete your project. So it's a good tool. A lot of boards do not use them or haven't even thought about using them. And so that's the only reason I wanted to mention them today. And again, I know some of you don't construct or maintain legal drains, but for those of you that do, I would encourage you to consider using these berm easements. I think you're gonna save yourself some headaches, and landowners are gonna feel like they were treated fairly. All right.
You're right, Sean, that we don't have any questions that have been submitted by chat, but if you do have questions, folks, probably the easiest way would be to send a chat message to the whole group, or to me, Lance, or to Jack, and we can forward them on the Sean, because we do have, all the lines are muted presently. So if you have a question, it'd probably be easiest to chat the question.
Yeah, sounds good, Lance. Thanks. Yeah, any questions on those, go ahead and submit them. And of course, if anybody wants a copy of a sample berm easement document or anything like that, let me know. I'd be happy to send you our most current version of a berm easement. So just let us know. Thanks again to Moore for doing that flyover drone picture. All right, maybe let's just talk about quick take eminent domain a little bit. Again, we've been living with the new Water Resource District quick take statute since 2017. It's a good time to evaluate where we are. I don't know how many people have used it. My boards have used it a few times. It's not something anybody relishes, but we've been through the process, and it is a process. And so I just thought it was a good time just to talk about it. Some of the issues that you run into under the statute are incredibly unique, and so it's just worth talking about. So the first thing I note here is that it should be a tool of last resort. That may seem obvious to a lot of people. I don't know that it is for everybody, and that'll become apparent here in a second. I'll talk about why basically why we ended up with the new statutory framework that we have is because I think some entities were maybe using quick take as sort of a heavy-handed negotiating tool. And so I think the design of the new statute, I think Jack was there when I sat down with Representative Robin Wise. We talked through the new statute. I think it was in the lunchroom of the Capitol, if I remember right, and Jack may have been there, or maybe it was Mike, but I think it addresses the concerns that he had, and Senator Dwight Cook was very involved. It really addresses the concerns that they had, and we've fought over quick take for a number of sessions, and I hope that that we're done fighting over that, because I just feel like this is a difficult statute to follow, but I think it addressed the concerns that they had, and one of them again was that some water entities were utilizing quick take as a large stick in negotiating, right? So it's a tool of last resort, and the idea, nobody likes to use eminent domain at all, but you've got to build public facilities, right? Whether it be a dam or a diversion flood protection project, or even legal assessment drains. These are important projects, so you have to balance individual landowner rights, which are sacrosanct, right? I mean, people view that as a significant right. That's part of our rights under the United States Constitution. So, I mean, how much more significant can you get? So you got to balance those rights with the rights of other taxpayers who need these projects. And so the tough thing is you want to treat people fairly. and most people are going to negotiate with you in a fair manner. What you can't do is allow somebody to hold a project hostage so that they can be paid 5 or 10 times more than their neighbors, right? And that's not fair to their neighbors, and that's not fair to the taxpayers who are paying for a project. So you got to balance those interests. So, but I just, as a quick warning, use it as a tool of last resort, and that's what it is. I think that's what this framework sets up for us, and very effectively. I mean, even if you wanted to use it as a heavy stick in negotiations, you couldn't, based on the statute. I'll get to that here in a couple minutes. But the differences between quick take and regular eminent domain. Some people maybe don't recognize there are differences, or maybe some people just feel like that are under the impression that quick take is eminent domain. Eminent domain means you're coming in, you're taking the property without due process. I hear that a lot. Well, quick take means there's no due process. That's not the case at all, right? And so we'll touch on that just a little bit. But the differences between the two, regular eminent domain and quick take eminent domain, are timing and the property interests that you're acquiring. The property interest in regular eminent domain, you can acquire in most situations. You can acquire fee simple. You can actually own the property as long as you use it for the project or the purpose that you're acquiring it for. You can't, just because you're getting it in fee simple doesn't mean you can turn around and give it to another private landowner, right? There's constitutional prohibition on that now, and there's a Lever's case in Jamestown. We can't do that. We can't acquire it and then turn around and give it to a private party for whatever purpose that they envision. But you can acquire, under a regular eminent domain, you can acquire something in fee simple. Whereas in quick take eminent domain, all you can acquire for water resource districts, and by the way, the statute for this is 61-16.1-09 subdivision 2. And again, this was enacted in 2017, or modified in 2017. Under quick take eminent domain, all you can acquire is an easement for a right of way, is what the language says. So you're acquiring an easement as opposed to fee simple. The other big difference is timing. So for a regular eminent domain action, you go through your process, you file, you fight with the landowner over values, may take a couple of years of litigation, and then at the end of that, that's when you get access. That's when you acquire the property, and that's when you get your access. The important thing for quick take eminent domain is that we've got to follow a pretty lengthy process to get to the point where you can file. But when you do file, immediately after filing, you have access to the property. Now, the landowner still has their constitutional rights, and you can litigate values and go through that process. And it may take 2 years till you know the outcome in terms of what you're going to pay that landowner or any other issues. But meanwhile, the important benefit of quick take is that you have access immediately. So you can, immediately upon filing, and again, there are several steps you have to go to before you get to filing. But once you file, you have access. And so you can commence construction of your project. And that's pretty important, again, for the landowner who's trying to hold out just to stop your project. It's one thing if a landowner feels like they're not being treated fairly in value. That's completely fair, and everybody should have the right to fair compensation, right? And if they don't feel like that you're offering to compensate them fairly, if they want to take you to court over that, that's their right. And they should be able to do that. And the Constitution affords that. But you also have situations where a landowner is going to hold out in the right-of-way negotiations as a tool that would attempt to stop your project. They oppose the project, they voted against it, and they're angry now that it's proceeding, and they're going to try to stop you, not through litigation over the project, but by holding out in right-of-way. And so if you have a permit that lasts only a couple of years, or if you have cost share that could disappear if you don't utilize it or something like that, that could really damage your project. So timing is important. Property interest is the other difference. And Water Resource District quick take was modified during the 2017 session. And a lot of you probably remember that. And we probably discussed it pretty significantly at the convention and maybe even at some summer meetings. I'll get to the changes here in a couple of minutes and what led to that. The last couple of points here are, again, don't use quick take as your heavy stick in negotiations. Don't come into negotiations with that in your back pocket and then pulling it out and setting it on the table and say, we're going to treat you fairly, but by the way, if you don't give us what we want, we're going to take your property. Okay, that's not the point, and the statute doesn't allow that anymore anyway. But don't try to utilize eminent domain as a negotiating tool. That's only going to get you into trouble, or even if it doesn't, it's going to get the rest of us into trouble, right? Because legislators are going to hear about that and they're going to be upset, and rightly so. And they're going to, because of the activity of one board, they may eliminate eminent domain for water resource districts, and that would just be absolutely devastating for water development in the state. So just be careful about how you use eminent domain, and especially quick take. Just be careful with it, because if you have a misstep, the next session we could lose it, and then you've ruined it for everybody, right? And that you're going to make project development just significantly more, exponentially more difficult. So just a background on why we ended up with the new statutory framework. During the 2016, and somebody can correct me if I'm wrong on these dates, it seems to me that it was during the 2016 interim that the Legislative Water Topics Overview Committee had heard about a water entity. It was not a water resource district significantly, but there was a water entity that was basically doing what I just described, using quick take as a heavy-handed tool in the course of negotiations. And the way it played out, and what I heard at the water topics hearings, was that this entity sent the very first contact they had with landowners in the right-of-way negotiation process. The very first contact was a letter that said, here's your purchase agreement, or whatever the agreement was. By the way, if you don't sign it and return it by X date, we will commence quick take eminent domain proceedings. And that upset several landowners, as you might expect. And I know Chairman Schmidt was not happy about it, and I understood the concern there for sure, because if the very first contact that you have, you're mentioning eminent domain, that doesn't feel like a fair negotiation, right? You're using it as a heavy stick. So what we saw was there were a number of competing bills in the 2017 session. One of the bills basically sought to eliminate all quick take for all entities in the whole state, including the state of North Dakota, the Water Commission, DOT, everybody, including water resource districts. We did not have to be, as water resource districts and as Water Users Association, we did not have to be out front trying to oppose that. In fact, we were probably near the back, because we felt like, look, we've been through these eminent domain debates before, let's let somebody else handle this. And the state opposed it, and a lot of other entities opposed it. And fortunately it failed, because it's an important tool, and if somebody's misusing it, they should be called on it, but that does not mean that it should be eliminated for all the entities, right? We have a lot of important projects to build. If one entity is not utilizing it correctly, should there be some punishment? Probably, but I don't think eliminating it for all the other entities in the state who use it fairly is the right thing to do either. So that bill was defeated, but there were a couple of other bills, and there may have been more. My recollection was there were 2 bills then that were directed at quick take for water resource districts in particular. And what happened is, after that first bill was defeated, the water resource district bill, the 2 bills stemmed from a situation where a water resource district, in this case it was a water resource district, did basically the same thing. Their first communication, and I didn't see any of the documents. I can't verify if this happened or didn't happen, but apparently a water resource district did the same thing. Their first contact after the vote their first contact with the landowners from whom they needed to acquire right of way contained a reference to quick take or eminent domain. I don't know if it was quick take or just eminent domain, but the first contact was the same thing. Look, we need you to return and sign this purchase agreement, and if you don't by X date, we're going to commence eminent domain or quick take against you. And that upset a number of legislators, and Representative Robin Wise, I know, was one of them, and he was very concerned. And I think he actually knew one of the landowners along the course of this project, and so he was understandably agitated over this tactic. And so the Senate bill that Senator Cook offered basically took quick take away from water resource districts and gave it to the county commissions. And it basically said, look, water resource district can develop the project up to the point where even, project development, everything else, and right-of-way acquisition up to the point where somebody is saying no. If you need to use quick take, then water resource district, you need to hand it off to the county commission. They will exercise quick take. When that's done, they'll hand it back to you. And that was kind of the idea. And Senator Cook's concern was that, well, water managers are not elected. And so we want this coming from an entity that's elected. And county commissions, you appoint water resource districts. So you should be the ones exercising this important authority. And I understand to some degree the sentiment that Senator Cook was operating under, that, look, this is an important tool, and if somebody's abusing it, the county commission should know about it. That sentiment makes sense. The Association of Counties was not too happy about it. They opposed it pretty vociferously. We opposed it. We didn't feel like the county commissions would want to basically come in and put on the black hat. Water projects are often contentious to begin with, and if you're asking the county commission, who may not even know about your project, I don't know, but they may not even know about it, and you develop it up to a certain point, and then you turn and say, hey, go take this property for us, and then turn it back over to us. That didn't sound terribly inviting to the county commission, so we opposed it. At the same time, the House bill that I think it was Representative Wise authored, or at least he was one of the co-authors, and he sought to basically just eliminate all quick take for water resource districts. And, we opposed that, of course, as well. And so what we ended up doing is we met with Representative Wise and talked about his concerns, and a lot of them made sense, right? We don't want water resource districts abusing this tool. We don't want them walking into their right-of-way meeting or sending a first letter to a landowner threatening eminent domain. We just don't want that happening. And that all made sense. And so we negotiated what we have now. And basically, what we have now is a pretty lengthy process. I've got a step-by-step, if anybody ever wanted to see how this actually works in practice. We've got a step-by-step outline of what you need to do and how long it takes for each step. And basically, you end up at about 7 months, 6 or 7 months. And so it's a lengthy process, and that assumes that everything works perfectly. And it requires a number of certified mailings and to make sure that landowners are adequately apprised of your project and adequately apprised of the values that you're setting. You have to send them their appraisal. And technically, under regular eminent domain, you don't even have to do an appraisal. Under quick take, you absolutely do. One of the other important things is you can't mention quick take eminent domain. So that makes things a little bit difficult. Let me run through this slide here before I get to that quick take eminent domain mention. The appropriation argument, one of the issues that under our old quick take statute was that the language said if the feds or if the state have appropriated funds for a project, you have a right to utilize a quick take eminent domain. And the state was very concerned that, well, the State Water Commission is how you're getting your project funds. And the legislature is not necessarily appropriating funds for a specific project. We all know how the funding process works in our state. For the most part, most dollars just go to the Water Commission. And, you know, we have the sort of the bucket process and things like that. Some of the larger projects are specifically mentioned in that appropriations bill, but most projects aren't, right? We have to be applied to the State Water Commission. Water Commission has their cost share policies. We follow that. Most projects aren't specifically identified by the legislature. And the State Water Commission became concerned that water resource districts were utilizing the quick take statute and arguing that, I know this because I was making the argument, we were arguing that, look, we have funds from the state of North Dakota, and so we have the right to use eminent domain, or quick take eminent domain. And the state concern was, well, but only the legislature can appropriate funds. The Water Commission can't appropriate funds. Well, the bill that Representative Wise came up with eliminated that argument. They just said if you have federal funds or state funds made available for your project, so it deleted that appropriation mentions, which was very helpful. So that just eliminated that whole issue. And the idea is, again, you can only use quick take when there are federal or state funds involved. And the idea is that quick take then allows you to protect those dollars, those cost share dollars. The federal government feels like, look, if we're giving you dollars for a project, we can't wait X number of years for you to finish your right-of-way acquisition process before you even consider constructing your project. If we're giving you these dollars, we need you to spend them. And so we can't wait for you to go through regular eminent domain. And that was the point. Same with the state, right? The state at the Water Topics Overview Committee, we often hear that, look, we being the Water Commission, the state, we approve cost share dollars on this list of projects, and they haven't even started construction. Why is that? And you know, we all understand that the Water Commission does not want those funds tied up. So if they approve the dollars, they want you to spend them. And so that's why quick take is very important, because if a landowner is going to try to kill your project and hold out, and we don't have quick take, and we can't get access to the property until the end of eminent domain, and any good lawyer can delay litigation, right? So let's say some right-of-way eminent domain action gets delayed for 3 years. Meanwhile, you can't start your project. So you got these state funds. The state has approved dollars for your project. If you don't have quick take, you got to go through regular eminent domain if somebody's holding out. And you can't have access to the property until the end of the eminent domain. That could be years. And a litigator in my office said, look, if I'm any good, I can delay this thing for 3 years, right? And so, you know, the state doesn't want to see that. They've approved these dollars. They need you to spend them. And so that's where quick take comes in. If you got these holdout landowners, let's fight over value. That's completely fair. But if you're going to hold out to try to kill our project, to try to get the state to take their cost share dollars away, that's not fair either. So that's where quick take is absolutely crucial for us. Obviously, permits are important too. They have deadlines. You know, sometimes you obviously we get our state permits. Sometimes you need your federal permits. You might need a 404. You know, you don't want significant delays, put your permits at risk. So that's where quick take is important. And again, just note that you're only acquiring an easement through quick take. You're not acquiring fee simple. And again, I can go through that detailed negotiation process. I'm not going to go through it step by step just because nobody wants to hear that now, but it's a very detailed process. The old quick take statute basically said, hey, negotiate, and then at the end, file. And once you file, then you have access. The statute is about 2 pages long now, and it requires pretty significant incremental steps. You got to go through 60 days of informal negotiations before you even start your formal process. You got to send them their appraisal. You got to send them a letter, certified letter with their appraisal and an offer to purchase. You got to wait X amount of days before you invite them. Then you have to invite them to a meeting, then Water Resource District meeting, to come in, make sure that they're face to face with you if they want that opportunity to negotiate with you. If you don't reach an agreement, you send them another letter X amount of days after that, indicating your intent to utilize or to take their property, really. Then, if you still can't reach negotiation, then you got to ask the county for permission to utilize it. I mean, it's a very detailed, lengthy process, and that's fair, right? It's an important tool. They didn't take, when I say they, the state and the legislature did not take our quick take rights away, but they did institute a pretty lengthy process. I think it's fair. It's a fair process. The last thing, again, you can't mention quick take eminent domain. So from a practical perspective, that becomes very difficult. Representative Wise, his point was, look, I don't want a water resource district to send a letter, the first letter to say, if you don't sign by X date, we're going to use quick take eminent domain. He didn't want to see that, and I understand that completely. On the flip side, we can't mention quick take eminent domain. So, you know, you have some landowners who, they understand this. They may come right out and ask you, if I don't sell you the property, are you going to take my property from me? Are you going to use quick take eminent domain? Are you going to, you know, you can't even discuss it. And so that's presents some pretty unique challenges, to say the least. Again, you do have to request county commission approval. So at the end of all of these negotiations, and I should step back, Representative Wise, when we were sitting there talking about this bill, this modified bill to negotiate that he could accept, that he'd be comfortable with, and that water resource districts wouldn't lose our quick take, he noted that, look, Senator Cook has a concern and I want to address it. And his concern is that county commissions appoint water resource districts. They're not elected, they're appointed. We want the county commissions to know that you're using this authority. And that seemed fair. And so what he came up with was, at the end of all of this negotiation, at the end of all of this quick take process, you've got to ask your county commission where the property is located if you can use quick take. And so then the county commission invites the landowners into a meeting, and basically one more opportunity for the landowners to face the water resource district, and at this point to face the county commission as well. And basically the county commission obligation is to just ensure that you're not abusing the process. Make sure that you've completed the steps and you are not threatening quick take. So at the end of the day, like I say, it's 6 or 7 months. It's a lengthy process. You got to follow it to the T. It's not easy, and it's not terribly quick. A lot of people call it medium take, not quick take. But I think it's fair. I think it's a fair process. It does not allow you any longer to utilize quick take as a heavy stick in negotiations. You can't send your first letter and say, send us back a signed purchase agreement, or we're gonna initiate quick take eminent domain proceedings. You can't do it anymore. The statute just doesn't allow it. So it's a fair process. It's pretty detailed. Just, you know, I guess I would say that before you commence your right-of-way negotiation process, even make sure you talk to, and I'm not trying to get business here, it doesn't have to be me, but make sure you talk to somebody who knows how the statute works. Because if you don't follow it correctly, then you're going to lose the ability to utilize it in that particular negotiation. And also, if you don't use it correctly and you continue to, if somebody threatens quick take, the legislature is probably not going to be very pleased to hear that. And so we don't want to lose this very important tool. So good point here to pause. I don't know if Lance or anybody, Julie, has gotten any questions. I'll take a quick sip of coffee. Any questions from anybody?
Yeah, take a breath, Sean. I have not had any questions texted to me in Bismarck. Jack, have you had any directed specifically to you?
I have not. I do have a question for Sean. I guess we went through the same comparison of timelines between a traditional eminent domain under 3215 and a quick take under 61-16.1. And I know Sean and I talked about it a couple months ago, but there's a statute 3215-13 which allows a one moment. Okay, sorry about that. It allows a government prosecuting a traditional eminent domain to seek a jury trial within, I think, 8 and 30 days. And I'm just wondering if Sean or if anyone else has tried that, and if I think when we've found cases where that was used, it really didn't speed up the process at all. So I'm just kind of wondering what Sean's perspective on that would be.
Yeah, thanks, Jack. No, Jack's right. There's in the regular eminent domain statutes, as Jack noted in 3215, you have the right to demand a trial, and it's sort of an expedited trial demand. And I have seen cities use it. We haven't used it. We'd rather not, but we understand that it's there. And I have heard anecdotally from some cities that I think, as Jack noted, yes, it's an expedited process. It's not as expeditious as you might think. And on top of that, let's say you're doing this, let's say Jack's working on the Service River project. If you don't have quick take and you feel like, all right, we got to get moving here, we're going to lose our cost share, we're going to, there are permitting issues or whatever the issue is. If you have, let's say you have 20 holdout landowners or something out of, however many, maybe there are 200 landowners and you have 20 holdouts. If you demand an expedited trial on 20 cases, I don't think the court is going to be terribly happy with you, number one. And number two, I think Jack's right. I think you're gonna find that you're still going to be working around the court schedule. So I mean, there are practical considerations too on top of that. I have, like I say, I have seen cities use it. Some have used it fairly effectively, but again, I would rather not have to rely on that, and I don't want to put courts in a situation where you're forcing their hand from a timing perspective. I don't think judges appreciate it, and I think it puts your projects at risk, and so to some degree, and so I just want to see us protect our quick take and just make sure we're using it in a reasonable way, so we don't have to attempt to rely on that statute. Yeah, no, that's a good point, Jack. I'm glad you brought that up.
Yeah, I agree with Sean. I think with the new quick take process, which is pretty lengthy to get through the process, and it's also administratively burdensome on meeting all the mailings and informal and then formal negotiations. Thought that maybe the thought would be that the traditional eminent domain process with the expedited jury trial request might not even be that much longer, but I don't know if it's actually, haven't been able to try it myself, so I don't know if it's actually faster or as fast as quick take, and I don't think it is.
Yeah, I agree with Jack. I don't think it is. I don't think it is. So the final lesson I think in quick take is a couple, well, two of them, I guess. Number one is don't be that board that misuses it, right? And tries to threaten somebody, because that could result in the legislature taking some action. We just don't want to see that. We can't put our projects at risk that way. And I guess number two is just that it's a detailed process. I didn't go through it all here just because it's lengthy and it's a little bit boring, frankly, but it's a detailed process. Just make sure that if you're going to utilize it, you have some counsel involved who understands how it works. So anyway, those are kind of my two takeaways. All right, covert disputes. Let's dive into this one. Like I say, covert questions are probably the most frequently asked questions that I face, and Jack probably gets the same thing. And so, like I say, I try to run through this every few years, and water managers run into these questions all the time, and townships will say, well, go ask the water board, or the county will say, go ask the water board. And I think the initial response, if there's some sort of issue with a culvert or drainage, the initial reaction and initial response is, well, it's a water issue, so go talk to the water board. And that, right, from a visceral perspective, that probably makes a lot of sense, right? There's water involved, so go ask the water board. But in a lot of situations, we just don't have jurisdiction. And when you're talking about culverts. And so I just wanted to outline the various culvert scenarios you may encounter. And I have a memo, it's a few pages long, that periodically I'll send out to townships in a county for the water, in the counties where I work for the water resource districts. We just periodically will send out this memo that, that sort of outlines what I'm going to go through here today, just to let townships and counties know, look, this is how this works. We understand you frequently encounter culvert issues and questions, and this is how it works. And so again, this is something that the Township Association hopefully will discuss, frequently at their conventions. So anyway, again, water resource districts often caught in the middle of these things. People assume that if you're talking water, then the water resource district must be involved, right? And then again, that seems like a fair assumption, but oftentimes that's not the case. So you need to understand when we do have jurisdiction and understand when we don't. And that's important, because if there's a scenario where somebody comes into the water board and says, hey, this upstream landowner wants this culvert, but the downstream landowner doesn't want us to allow it, we want you to make the decision. If you get too heavily involved in a situation where you don't have jurisdiction, then you may end up in litigation, right? And some people like that, and I'm going to move here because of the sun. Some people like that. Of course, I probably shouldn't be giving you this advice because it means less business for lawyers, but I don't want to see you in litigation if you don't need to be. And so don't offer, even sometimes people really don't like to hear me say this, but I hesitate to even give advice, right? You're the experts, you're the water experts, so you probably know best about the culverts. But a lot of times, even in a passing discussion, if a water manager says, well, I would put in a 48, if a township follows your advice, that thing ends up in litigation. At the very least, that manager is going to be a witness, or potentially the water board could get sued, right? If some downstream landowners claiming damages or whatever. So, these can be significant situations, but also I just want to save you some time. Sometimes you'll get engrossed in a scenario where, parties are disputing culvert sizes, and it may last months, and you may end up spending a bunch of engineering dollars only to find that, oh, we didn't have jurisdiction. So if you know this stuff up front, you may protect your general fund to some degree. So I want to go through a few, really the 4 typical culvert situations with road crossings. So legal assessment drains, and most of us know what those are, right? Those are legal assessment drains are drains that have been voted in, and where there's an assessment district that is responsible for financing and funding the maintenance, operation, and construction of the legal assessment drain along the course of a drain. Legal drain and intercept culverts would be the drains along a drain that discharge water into your drain, but it's not necessarily along the course, right? You're not intersecting a township road or a county road, but these intercept culverts sort of discharging into your drain. Standalone section line culverts, what I mean there is, by standalone, is there's no legal drain involved. There's not one anywhere near. So that's another category. Another category would be approach culverts. These aren't even on township roads or on county roads. They're culverts through approaches within the road right of way. Railroad crossings are addressed in the same statutes and are a little bit different. So again, legal assessment drain, road crossings are the culverts along the course of your legal drain. And those are water resource district jurisdiction. And by statute, 6116.1 42 and 6121 31, you can order a road authority to install a new culvert or crossing to accommodate your drain. So if you have a new drain, just got voted in, and the drain along the culvert along the course of your drain through X township road is only an 18-inch and it really requires 2/48, then you can compel installation of the new culverts because you have jurisdiction over that crossing. Or similarly, if you have an existing drain, you know, a lot of drains, I think of Sargent County, for example, a lot of drains there were built in the 1900s, the early 1900s. You know, a lot of those drains, obviously, watersheds have changed, things have changed, right? And so you're going to have to upgrade in many cases. And so even if you have an existing drain, if the existing culvert isn't sufficient, you can compel the road authority to install a new culvert to accommodate your drain. So, I mean, you know, a lot of times those old ones, they were 2-year crossings, for example, whereas you're going to want 10-year in a lot of cases, right? So new assessment drains or existing assessment drains, you can compel the road authority to provide you your crossing. So this is the statute in chapter 61 and 16.1, and this is a pretty significant one. There have been a fair number of lawsuits over this, Supreme Court cases even, over the statute. And so this is the magic language that requires a road authority to install a crossing to accommodate your project. And again, we, as water resource districts, we have sole jurisdiction over this. As long as we can demonstrate that it's necessary to accommodate your drain, then the road authority does have to comply. And I'll get into some process issues here shortly, but we do have the authority to order that road authority to accommodate your drain. So talk about who pays for it exactly. If you're talking about a county or township road in chapter 61:16.1, even if it's a township road, the county will pay 40% of the costs, and the water resource district pays 60% of maintaining. This is of maintaining. Sorry. Townships in 61:21, I think they have to pay the first $500 or something like that. So, you know, there's a 60-40 split, except in the old 61:21, townships got to throw in $500, but the county's on the hook for the installation, operation, and maintenance of that crossing at a 40% rate, and the water resource district's at 60. DOT, they've got to pay the full 100%. So there's no 60-40 split there. It's all DOT's bill. So it's pretty significant that those costs can really reduce the costs for the members of the assessment district. The last piece I note here, and just again, I just want to reiterate that if you're talking about a township road, the county has to pay 40%, even though it's a township road and not a county road. So I just want to make sure that's clear. The last bullet point there, issue an order and follow process. So this is important because you want to engage these road authorities early in the process so that they understand that this is coming, right? A lot of counties don't have the funding to simply provide a $250,000 crossing at the drop of a hat. So you want to make sure you engage these entities early in the process, make sure they understand and know that it's coming, and maybe they can budget for it. Even if you know in advance, a year in advance, you give them a heads up so that they can try to budget for it for the next year. Same with DOT, right? You want them to understand that this project is coming. You want to make sure that, for a couple of reasons. One is funding, and another reason is that, you know, they've got their federal highway requirements, and you're going to have to jump through more administrative hoops. And so, you know, you're going to have to make sure you get sign off from NRCS and all these other issues when you're dealing with a DOT crossing. So make sure you give them enough time, enough lead time, and a heads up. oftentimes you may have these negotiations early in the process, and they may say, okay, great, here's the date we can get it done. You know where you stand. Sometimes you don't, and sometimes the road authority, they're non-responsive, or they're just saying, well, we don't think you need it, or I think the crossing that's there is sufficient. In that case, you may have to issue an order to compel the road authority to install a crossing, and maybe offer them a hearing. There's no statutory process necessarily set out, but what you might want to do is give them notice of a hearing and invite them to a hearing, and allow them to offer their engineering reports, and at the conclusion of the hearing, issue an order, something that they can appeal to district court if they so choose. But follow a process, and don't surprise a road entity at the last second. Intercept culverts, again, these are not along the course of a drain. These are the culverts that discharge into a drain. Obviously very important as well, especially when you're talking about members of the assessment district, right? They need maybe a road that is adjacent to your drain, and the members of the assessment district on the opposite side of that road, they need to get into that drain, right? So those intercept culverts are incredibly significant. The ownership is a little different here, and the jurisdiction is a little different here. Unless you're designing it as a component of your drain, in which case you're going to have to negotiate with the road authority. But unless that's the case, it's typically shared jurisdiction, right? Whoops. What did I just do here? Okay. Yeah, here we go. Sorry. Jurisdiction. Road authorities and the water resource districts share jurisdiction. And this stems from a Supreme Court case down in Richland County. And again, unless you're designing it, the intercept culvert, and it's a component of your project and you're willing to pay for it, you can't order the road authority to install it at their expense. If you do it and include an intercept culvert as a project component, and you negotiate with the road authority and it works for them, and you're going to agree to maintain it or whatever your agreement is, unless that's the case, you have shared jurisdiction, is what the Supreme Court has said in terms of these intercept culverts. We don't really know what that means. There's no statutory language that gives us a full description of what that shared jurisdiction should look like. The Supreme Court just indicated, look, if you have a culvert that's going to allow water to enter your drain, the intercept culvert, they share decision-making authority, they being the water resource districts and the road authorities share jurisdiction. And so again, no real statutory description of what that means, and really no judicial description quite yet. So you have some shared jurisdiction. Again, same thing, work with your road authority. But you in those instances, you're involved, right? Oh, that's just a description of the Eichhorn case down in Richland County. I don't think we need to go through this too much. So these intercept culverts are important for the members of your assessment districts, and you have some ability to protect them. A road authority can't just decide to put a cap on a culvert or remove a culvert or take 248s and turn them into a 18. So you have some shared jurisdiction. Sometimes that shared jurisdiction is not all that friendly. Sometimes it works and you're in perfect harmony, right? But just recognize you have some shared jurisdiction.
Hey, Sean?
Yeah, Jack.
Hey, we've got a couple questions here, and I'm just wondering if we could take a break.
Let's do it.
And have, so we got John Kippen asked a question, and John, if you would be able to just unmute yourself and maybe ask the question out loud so we can engage in some conversation about your question.
Yeah, I was curious on does the DOT have any statutes that preclude us from putting drainage systems in the right of way?
So the statute allows it actually, but they have federal highway requirements. And I've run into this situation. There was, it was probably 8-9 years ago, where the county we were working with was cooperating with us, and we wanted to install a legal assessment drain that ran in the county ditch, and then also ran in a portion of DOT's ditch. We ended up coming to an agreement and modifying the project a little bit, and DOT bent a little bit our way, but we do have statutory jurisdiction to do it. North Dakota State statutory jurisdiction. What you might hear from DOT is, look, federal highway isn't going to allow this. We have some environmental prohibitions, and we ran into that. And basically what they ended up telling us is look, we can't do this. We're going to lose our federal highway dollars the way you have it designed. And if you're going to do this, we're going to have to go through the full NEPA process. And I mean, even if we have state statutory jurisdiction, I think they can, if DOT is running into some federal issues, they can make our lives very difficult. So from a statutory perspective in North Dakota state law, we have that right, but just recognize that if DOT doesn't want it, they can make your life pretty difficult and make it practically almost impossible.
So by the federal rule precluding us from paralleling a drain where it's most efficient inside the right of way?
Well, there's not any specific statute that prohibits it, but there are some federal highway rules that are going to make your life difficult in getting there, right? Because you're going to have to go through some environmental reviews, and they can be lengthy and expensive, I guess that's what we ran into. And we just made some modifications so we wouldn't have to do that and make our life difficult and make DOT's life difficult.
Right.
Yeah, good question, John.
Basically, federal statutes. Yeah, you answered my question. It's the federal statutes that are impeding progress of right away.
Actually, it's federal highway rules. There weren't any statutes. It wasn't in the United States Code or anything like that. Just federal highway rules.
A legal drain is a utility, so, and that's partly what the highway right-of-ways are for. So,
no argument.
Thank you. All right, I'm done. Thanks.
Thanks, John.
So the next question is from the Walsh County Board. So if the Walsh County Board could, or I can ask it on their behalf.
Larry and Jennifer.
Yeah, we're here.
Hey guys.
So I think I'll let Larry ask. He's the one that had the question.
We have a legal drain. Hi, Sean. We have a legal drain that crosses a county road. Now, at one time there was a culvert through the county road, and then we put a legal drain across the county road here a couple of years ago that increased the size of that culvert.
Okay.
Who has the jurisdiction over that legal drain? The county says that they have the jurisdiction over it, and we're saying we have the jurisdiction. So when it comes to from FEMA funding, she filed, the county engineers filed for FEMA funding on it, and we filed for FEMA funding. And she said she has the jurisdiction. So who has it in a legal drain course?
So, FEMA may have different rules, Larry, and in terms of what FEMA's looking at, that might be one thing, but under North Dakota law, the Supreme Court's pretty clear, very clear. Those are our jurisdiction. Along the course of a drain, those culverts are our jurisdiction. Now, where it gets sticky is, all right, the highway department needs to do an overlay or something like that, right? You don't want to be responsible for that, a 60-40 split on on repaving or something like that. You have jurisdiction over the culvert. And so don't get carried away in terms of your order. We have jurisdiction over from this, and you describe a legal description from here to here, then you might be responsible for maintaining a road, right? But you have jurisdiction over the culvert.
Yeah, okay. Yeah, because this culvert has washed out 2 times already, and we wanted to change it, and then all of a sudden the county engineer says, no, I'm gonna do it the way I want to do it, and that's what she did. She just took it and did it.
Yeah, no, you guys have that jurisdiction. That's your jurisdiction. Now,
Okay.
sometimes what we'll do, you know, sometimes you run into situations where they're talking about safety issues or something like that. And, you know, we don't want to be paying 60% of a safety project or a road safety project, right? But if it's related to the culvert, it's going to impact capacity, it's your jurisdiction.
Okay. Is that the way that always been, is that 60-40 split? It always included the maintenance and the construction? If you're putting in a culvert to a county road and you put the way they designed the culvert, put gravel, fabric, and culvert in through that, was that always, is that the way that North Dakota law states it is, 60-40 split on all that?
For 16.142 has been in place since 81, and 61.2131, and I can't remember what year that was enacted. And I think the 60-40 split, I can't remember how long in chapter 6121 the 60-40 split's been there, Larry, but it's significant number of years. But as far as I can remember, in terms of chapter 6121, it's been in there. They may have modified the 60-40 when they enacted chapter 61.16.1. So at least back to 81, I think before that.
But it always included the construction and the installation of the culvert from.
Mm-hmm.
Okay.
Yep.
Okay. Okay. Thanks, Sean.
Yeah. Thanks, Larry. I know Walsh County has large, I forget the drain number that they're working on.
87.
87. My gosh, it's one of the biggest drains you'll ever see. It's pretty remarkable, pretty impressive to see. So I know they're busy with legal drains. What, Jack? Sorry, what was that?
Okay, sorry, I was going to jump in. We have one more question, I believe, from Jeff Fritz.
Hey, Sean. Hey,
Hi, Jeff.
Quick question for you. What can or should be done to somebody who took it upon themselves to put in additional culverts and approaches off a county road and through a township road?
So an individual landowner or whatever, somebody took it upon themselves to install culverts through a township road?
Well, they went through a township road, and then they went additional culverts through in field approaches off a county road without checking with anybody, really.
And they discharge into your legal drain, or?
No, they did discharge down to other private landowners.
Okay.
Okay.
Yeah, so that's pretty similar to what I'm just about to talk about now, Jeff. So if you're talking about a standalone section line culverts, this would just be, any township or county road where you don't have a legal drain involved. We, being water resource districts, we don't have any jurisdiction. The Supreme Court has been very clear about that. There have been, I want to say 4 cases, if I can remember, Ness, Cadillac, Fandridge. There are a number of cases that say, look, if it's a culvert through, well, any road, any highway, or even an approach like you described, Jeff, we don't have any jurisdiction over those. So you're going to have to go to the road authority and deal with them. And so the road authority, hopefully they're not allowing people to just go and install culverts at their will, their own will. They have to meet, they being the road authorities, they have to meet the stream crossing standards. That's their obligation. So unfortunately, or fortunately, depending on how you look at it, Jeff, it's not the water resource district battle with regard to some of those culverts. And if you get yourself into it, those are the situations where if you get yourself into it, that could be some really long protracted litigation where in the end, you as the water resource district don't have any jurisdiction. Some water boards are very pleased to hear that because they feel like, look, we don't want to be in the middle of this dispute between these landowners and the road authority. Others feel like, hey, we're the water board, we should have some jurisdiction over this. We know how, we're the experts, right, on drainage, so we should be involved in this. And there are different trains of thought on that. I would caution, some people say we should have some legislation saying we do have jurisdiction over these standalone section line roads. I would caution against that, just because you may need a full-time staffer dealing with culverts, right? Most water boards can't afford that. So if somebody were to request that kind of legislation, I would also say, okay, then make sure that there's an appropriation for every water resource district, or an increase of our general mill levy, right, from 4 up to 10 or something, because you're gonna be busy, right? Every single culvert issue that comes to you, if you're responsible for every culvert in the county, you are gonna be busy. So, like I say, here are some of the cases. This Cadillac case in '98. If you're talking, Jeff, I'm sorry. Did you have any other follow-ups on that issue?
Yeah, so really it should be put upon the county state's attorney or the road authority to take any type of action against the individual landowner who had, took it upon themselves to put additional culverts in without getting proper approval from the water resource district, or getting a stream crossing standards done, or anything like that.
Yeah, if a private landowner, so we had a situation in Ransom County where there was a drainage complaint against somebody who, in this case, the landowner had constructed a brand new ditch, a huge, significant ditch, and then actually cut through the road and put in a culvert. We were able to get the county involved there, because the state's attorney involved, like you say, Jeff, because look, they cut through a county road. I mean, that's significant. Same as a township road though, right? Same thing. We had a drainage complaint related to the ditch. We ordered them to close the ditch, but the Supreme Court is very clear. You look at this Cadillac case, Supreme Court has been very clear. Look, Water Resource District, you don't have any jurisdiction over that. That culvert and that road, those are not your jurisdiction. So we handled the ditch. We ordered him to close and fill the ditch. And he refused. We ended up doing it, and we assessed the property under our statutory authorities. I mean, it was a long, drawn-out situation, but we handled what we had jurisdiction over, which was the ditch, and the county state's attorney prosecuted for cutting through the road and installing a culvert. And so that worked out. I mean, only a water nerd like Jack or Lance or me would find this interesting, but that worked out exactly the way it should. We had jurisdiction over the ditch. We took action based on the complaint, filled it in, and we went and assessed, and it was a thing of beauty, right? And then the county, they prosecuted, and actually, I don't know if the guy served jail time or what. I mean, it was significant. So, but yeah, right. If somebody cuts through one of your township roads or county roads, Water Resource District, you don't have any jurisdiction over it, but get the state's attorney involved to the extent that you can. Because again, the Supreme Court is very clear, and here's one of the cases. Unless there's some sort of legal assessment drain involved, either along the course of a drain or as an intercept culvert, unless you have a legal assessment drain involved, hey, water board, you don't have any jurisdiction. And again, some boards are thrilled to hear that, and some boards are not too happy, but that's what the Supreme Court has said. Here's another one, the Ness case, same year. Jeff, any follow-up? Any other questions on that?
No, that kind of answers my question, Sean, so thank you very much.
Sure, thanks, Jeff. This is just another one of those Supreme Court cases, same thing. Hey, water boards, you don't have any jurisdiction. The standalone section line. So I just note that there is a statute in chapter 61 to 16.1 that says that if a township board is going to modify a culvert, they have to notify that's going to impact drainage. They got to notify the Water Resource District. None of them ever do it, but here's the statute. Oh, yeah, it's in 2406, sorry. And we can provide comments back if we want, but they're supposed to provide us notice if they're going to modify their culverts. None of them ever do. So, and there's no remedy if they don't, right? Approach culverts, and I think we're probably running out of time, but approach culverts, again, just like Jeff was just talking about, we're not talking about a culvert that runs through a township road or a county road. We're talking about an approach within their right-of-way. The road authorities have jurisdiction over those. If somebody obstructs one of those culverts, then we could have some jurisdiction under a complaint statute, the obstruction statute, 61, 16.1, 51. So that gets a little bit convoluted. I'm just going to run through it. Oh, to this point, the stream crossing standards. I bet you've all heard it, and maybe you've even said it, but people say it all over the state. A road can't act as a dam. They think that's the law, right? And it sounds nice, but actually, the law says the statutes are very specific in terms of what road authorities have to do. So if you're installing a new culvert or a new crossing, or if you're reconstructing an existing crossing, your obligation is to comply with the stream crossing standards. That old saying is not necessarily the law, right? So your obligation as a road authority is to comply with the stream crossing standards. So you're talking 10-year for a township road, 25-year typically for a county road, typically 50-year for the interstate, things like that. So that's the obligation. It's that old saying doesn't necessarily hold up anymore. There's a lot more here. Railroad culverts, they have the obligation to install. Yeah, Jack.
Before we move on, we did receive a question from Dan Steinberger, and I think it really is pertinent to what you just talked about. And so, Dan, I could either read your question or else you can jump in and ask it yourself. So I'll just read it. If the landowner has property on both sides of the township road, do they have a legal right to install a culvert?
So it's sort of a difficult answer. The answer is only if the road authority is constructing or reconstructing a crossing. So if the road has been the exact same way for 75 years, then no real legal right to install a culvert through that road, or no legal right to compel the road authority to install some sort of crossing to accommodate you. If they do any type of reconstruction of that road, then they have to comply with the stream crossing standards. So, if they're just doing a re-gravel, or, they're laying down some pavement or something, does that rise to a reconstruction under the statute? Probably not. But I mean, if they're doing a major modification of the road, in that case, they have an obligation to get a hydrology study and determine what the stream crossing standards require. So if that road's been there for decades and hasn't changed, there's never been a culvert there, then there's no legal right for the landowner to get some sort of crossing installed. That makes sense?
Thanks, Sean.
Yeah, thanks, Jack. Again, we're kind of running out of time here. I just wanted to touch on railroad crossings. There have been a lot of cases on these. This comes from the same statute, 6116.142 and 612131. Same thing. If you're doing, in terms, basically treat them like DOT. If you're doing a new legal drain or reconstructing an existing legal drain along the course of, and the culvert is along the course of your legal drain, and it runs through or intersects a railroad, they have an obligation to provide the crossing for you at their expense, or to provide an enhanced crossing to accommodate your drain at their expense, 100% their cost. Same thing, work with them in advance. There's been these types of situations have been in front of the Supreme Court a number of times. Railroads have brought bills to the legislature on these issues. And just as a quick side note, the reason this statute exists, and they have statutes like this throughout the country, and they've been litigated very heavily. The rationale for these statutes is that the railroads were granted these properties for free, right, by the United States government. And so as a result, many states have these statutes, and even the US Supreme Court has said they're constitutional. They're not takings. They're not a constitutional taking. When you order a railroad to install a culvert to accommodate your drain, they're not takings because the railroad acquired these properties for free from the United States government. And so that's why they're on the hook for 100%. In most situations, only to accommodate legal drains. If there's no legal drain, you can't order them to do this. But work with them. They have budget processes too, and you know, we've worked more closely with, for example, BNSF over the last several years, and we try to give them advance notice, and we work with them on their budgeting process. They have to go through Fort Worth, and it's you know, it's a mammoth task for them to get these kind of dollars budgeted, and so we work with them as closely as we possibly can, just because they have to jump through their hoops on their end too. But they've been a lot more accommodating. They understand the statute's most likely going to succeed or stand up against any judicial review, and so if you go through a process, same thing, follow a process. Don't just show up, here's the statute. Don't just show up the day before you start construction and say, we need a crossing. You know, follow a process, issue an order and follow a process. So Jack, I see we're out of time. I kind of ran through this culvert piece a little bit fast, but if anybody has questions about any of it, you know, feel free to touch base with me, give me a call, shoot me an email. Let's talk about it.
John, this is Don Kemp, but am I able to talk to you here?
Hi, Don. Yep, we can hear you.
Yeah, I know you're a little bit familiar with Eminent County, what's happened with St. Thomas here. A question would be like, the water, there's a pair of culverts within the city limits of St. Thomas that crosses what would be like a township road in one of our county drains. And that needs replacing. And the Water Resource District is willing to do our 60%, but when we approach the county, what they have been doing is abandoning bridges and in these kind of situations where there is other access. So is there any recourse like for the people of St. Thomas with the county other than going to a court or?
Well, yeah, I was just gonna say, Don, I mean, you're gonna have to go to court, right? To compel them to pay their 40% share. I mean, if you're talking like a section line or something like that, I mean, it's very clear they're abandoning the entire road, or what are they doing?
They would just take out that that portion there, so that it wouldn't be obstructing. It's like a 10-year event with two 50-year events, a 50-year event entering St. Thomas, and then a 10-year event in St. Thomas where it crosses Drain 67. They would just prefer to remove that street or township road crossing.
Well, you know, they still have an obligation. It's along a section line. It's still their obligation. I guess the way I would do it to try to force their hand, and I don't know, maybe you guys have already been through some proceedings. And I know Don's mentioned this. It's in Red River Joint Board meetings, and I know it's been an ongoing and very contentious issue. So you've probably followed a process already. I don't know, but what I would probably do is issue an order compelling them to provide 40% of the crossing costs. If they refuse, and issue an order, give them an opportunity rather to appeal your order to district court, because anybody can appeal a decision of Water Resource District, right? You have 30 days to appeal a decision. Give them notice, be very formal about it, give them a chance to appeal. If they don't appeal, they run out of their, they miss their 30 days and they still refuse, then you could initiate some kind of declaratory judgment action or potentially writ of mandamus or something like that. You'd have to think about the tool you want to use, the litigation tool, but to compel them to pay their share, and just note that they already missed their appeal right, And so they have a legal obligation. That's why I say writ of mandamus. They have a very clear legal obligation to provide it. They would argue that, well, we abandoned, so it's not a clear legal obligation. But anyway, to try to compel them to pay their share. You got to get it into court somehow, and that's how I would do it. You're going to have a court tell them that they're going to have to pay their share. That's the only recourse you're going to end up having, right? And it's going to have to be the water board. It's not going to happen.
But does that apply in all cases?
I will never say that something applies to all cases.
Does that mean in all cases? Like
What's
when
that,
there would be two other accesses to the city, actually on the state highway. Do they have an obligation to do this even when there are other ways to access the city?
Well, it's not to provide a perfect bridge crossing or something like that, right? If it's their road, they have to, the statute says they got to provide their 40%.
Okay.
And again, I do know, I've heard there's some legislators involved. Hopefully they don't try to fiddle with our statutory rights here. I know it's a very contentious issue. So there's probably no easy answer, Don. That's just from a outsider's perspective, just from a procedural standpoint, that's how I would approach it. And you guys have maybe already done something similar or different. I don't know, but that's how I would approach it procedurally.
Okay, well, thanks, Sean.
Yeah, thanks, Don. Anybody else have questions?
It doesn't look like it. So I guess we did have a comment from Cale Van Bruggen. And Cale, if you want to explain.
Hi, Cale.
Hello. No, good presentation, Sean. Just as an addition to what you're talking about with railroad culverts.
Yeah.
Federal Railroad Safety Act.
Yeah.
And rule citations. Sometimes I've made notes to those or given those to water boards or landowners to bring to the attention of the railroad that's moved the needle on a railroad that's resistant to maintaining a culvert. So keep those in mind.
Yeah, Cale, sorry, go ahead, finish.
That's it, thank you.
No, Cale brings up an important point. So, you're dealing with interstate commerce, right? So there are a number of other federal rules that could apply that could, in some ways, inhibit your ability to compel this crossing. If you're talking about safety issues, or if it's viewed as an obstruction to interstate commerce, those would be, and I have seen in other states, those attempts by railroads to try to stop this type of thing, and that is an important point, and that's why that's one of the reasons why we engage them early, and we've worked pretty closely with a lot of BN's people and try to basically give them a year heads up, because if they can put it in their budget, then they don't, and they have an alternative plan for that particular area, then they can't argue it becomes a safety issue or that it's some sort of interference with interstate commerce. But Cale's right. There are some other federal statutes that could apply that could impede your ability to compel the railroad to provide your crossing. Now, like I say, we've worked pretty closely with BN, Red River Valley, Western, Dakota, Missouri Valley. They're usually pretty cooperative. We've developed a better relationship with BN over the years. We've still had a couple situations, though, where they've tried to challenge our efforts. We started working with them. I'm trying to think of one in Trail County. I think it was probably a year in advance. And I know early in the process, they started making these interstate commerce and NTSB type claims. And because they had an alternative that they could turn to, and we gave enough time to come up with some sort of alternative route or alternative plan, just in talking with their counsel, they said, well, we probably can't make these claims in this situation. So in that case, when you're dealing with a railroad, you absolutely have to give them enough advance warning. Otherwise, they're going to have a number of federal statutory arguments against your state statute. So that's a very good point that Kel made. So just make sure, again, you're working with the railroad as early as you possibly can to avoid those types of situations where you're going to run into federal arguments. And of course, federal preemption comes into play if that's the case, right? There are federal safety requirements, federal interstate commerce type requirements. Those are oftentimes those can preempt your state legal rights under 6116.142 and those types of statutes. But if you give them advance warning and you can identify, and sometimes that's not going to be a cure-all, right? They're still going to have those arguments available to them. And sometimes federal law will just flat out preempt our state rights. So that is an important point.
Well, thanks so much. Thanks so much to Sean for presenting. This topic gets a number of questions, and that's why we're already a little bit over here. So thanks for everybody for participating. And as Lance mentioned in the chat function, all of these presentations are available on our website. I guess with that, we do have one more question from John Martinson, and then I think we should sign off. So John, if you want to.
Can you hear me?
Yep.
Sean, we have a drain in the northern Devils Lake Basin that's called the Edmore Coulee, but it's not an assessed drain. Are any culverts that contribute to that drain would be an intercept culvert, or would that be solely the road authority's jurisdiction?
John, if it's not a legal assessment drain, you're not going to have the same protections under those Supreme Court cases. So if it's not a legal assessment drain, it's just I don't know if it's a natural drain or if it's just a private drain or a drain that you decided to maintain with your general fund. If it's not a legal assessment drain, you're not going to have the same protections or the same.
So the road authority would have
the
authority over those culverts.
Right. Exactly.
Okay. And once it is because right now we're in the process of trying to get a project passed to turn this into an assessment drain. So if that does pass, then at that time, would it be the resource districts, or does that not change?
Yes, once you make it a legal assessment drain, because water boards do that all the time. They'll take a natural drain, or even a privately maintained drain, and they'll turn it into a legal assessment drain. They'll go through a vote and turn it into a legal assessment drain. In that case, then those culverts along the course are subject to that 60. Water Resource District has sole jurisdiction, and they're subject to that 60-40 split. And then if Intercept Culverts, you share the jurisdiction with the road authority. Yeah. Yep. So even if it's an existing drain, if you turn it into a legal assessment drain through a vote, then you automatically enjoy those statutory rights and the rights afforded by the Supreme Court for legal assessment drains.
And any culverts that add water to the legal assessment drain would be then classified as an intercept culvert?
Under the Eichhorn case in Richland County, that's basically the test. If you have water that discharges into or enters the legal assessment drain, and again, it's a little cloudy, that Supreme Court case, if you read through it, it doesn't provide precise direction, but that's the language. Then you have some sort of shared jurisdiction. The further away you get, of course, the more gray you have, right? If you're 300 feet away, that's one thing. If you're 3 miles away, well, that's another issue, right?
All right. Thank you very much.
Yeah, thanks, John.
All right. Thanks so much, everybody.